Good evening. Captain Retired Matt Edwards here on the 30th of May, 2024 with the weekly Observation Post Facebook Live update. Now, I was watching a lot of the Donald Trump trial, and today, just a half hour or so ago, maybe an hour, there was some vindication for people like myself who think that someone who's guilty of sin like that should not be the president, should never have become the president, and has been getting away with crimes for the longest time. So finally has been found guilty on 34 counts of fraud to basically steal an election back in 2016. And I will, sometime during this broadcast, relate it to how a similar thing happens to Canadian insurance. But let's go on to one of my first points today. I'll go through my first observation post, group posts today. And I put it 3 today because I've been triggered for the last 2 days because of a very poor incident event with the Canadian Forces Ombudsman. I called them yesterday and I wanted to bring something up because I looked it up. It was on the 4th of April. That I submitted a complaint about the Canadian Forces and the Veterans Ombudsman, and I asked them to investigate the Service Income Support Insurance Plan, Policy 901-102. Now, the reason that I did that is that these programs, the Income Replacement Benefit, IRB, at Veterans Affairs Canada, that is subsidized by 83.33% by the Service Income Support Insurance Policy Plan, Policy 901-102, in that since a person gets medically released from the Canadian Forces, they automatically get CISIP long-term disability as of 1999. Before that, it wasn't automatic. But after it was made automatic, you see, the government had this low-hanging fruit that they decided when they changed the system in 2006. They decided that they would make the Service Income Support Insurance Plan payment, which was already automatically going to be paid to every person who gets medical release. By making that the base payment and having the Veterans Affairs payment top it up, but both of them were 75%. So by topping up one payment with the other payment, basically they were saying they were going to subsidize the Veterans Affairs program by making the disabled Canadian Forces member pay for their own disability with their own premium-based insurance, which is against the law, you see, the common law, okay? Oh my, I'm only down to the third post for today, and I wanted to get to the first one to talk about that one first. So, I'll get there eventually, bear with me. Now, damn, I got a lot of pictures. See, what happens is I make these posts, okay? I have been afflicted, unfortunately, with a thing called obsessive-compulsive personality disorder. And I can't stop looking this shit up at all, even though I know it's a colossal waste of time, generally. So this is the reason I ended up calling the Canadian Forces Ombudsman yesterday, and I ended up spending 30 to 35 minutes arguing with Nikki, her name was. And I only know about the name because I ask them their name, but then I promptly forget it usually. But at the end of the call, I decided that I'd like to speak to that person's manager. Now, she said that I would get a call back before the end of the business day, but I never got that call, which doesn't surprise me. So then I got an email, I noticed, from that person's superior, and they wanted some basic information, you know, name, rank, release, and all that stuff, which I didn't provide them because they ought to have it there already. And I explained that, you know, it's really not their job to argue with someone who's making a report. Okay? So if I'm making a complaint, making a report about something going wrong, the person that's a public servant is not supposed to try to dissuade me from making a complaint. They are not supposed to gaslight the report. You see? So I found the first one. So I'll whip down through it. Now, I don't have a very good opinion of either the Canadian Forces or the Veterans Ombudsman. Frankly, I think they're both a waste of time and resources. Now, this is not just my own opinion, but my first post for the day, I decided to lay right into the Canadian Forces Ombudsman because they are entitled to a lot of criticism. So I said, today's initial post will concern a possible cover-up by the Canadian Forces Ombudsman or the CFO after another failed attempt to report things to them yesterday. With that in mind, I will lay out why I think they are doing a poor job. Number one, the spring 2015 Office of the Auditor General, or OAG, report sharply criticized the Canadian Forces Ombudsman for being incompetent. I will list the four main headlines, and I might comment on them, which I did by copying and pasting parts of the report with the headline. Paragraph 7.13. National Defence did not fully define its roles and responsibilities for monitoring the administration of the Office of the Canadian Forces Ombudsman. Overall, we found that National Defence, the Department, did not fully define or document its roles and responsibilities for monitoring the administration of the Office of the Ombudsman for the Department of Defence and Canadian Forces. The Ombudsman was treated the same as other senior departmental managers in some cases, but not others. Why wouldn't they? It is my expert opinion that the government sets up these ombudsmen to make it appear that they care when they don't really care to have us make complaints. Paragraph 7.19, the second item I put in here. Inadequate financial controls and overriding of existing controls by management led to non-compliance of the rules. Overall, we found that an inadequate system of internal financial controls and the overriding of existing controls by management led to non-compliance with rules within the Office of the Ombudsman for the National Defence. In many cases, between 2009 and 2013, the Office did not follow rules related to the approval and disclosure of travel and hospitality expenses and to the management of contracts. Now, I've looked into contract stuff with SISIP in the past, and contracts for the federal government is covered by the Financial Administration Act and the Government Contracts Regulations. So these people said that they didn't do a very good job on contracts, but I guess the real question is, did they break the law? The third point I would make, paragraph 7.54 of the report. The previous ombudsman and senior managers did not respect the values and ethics code, and National Defence took insufficient action to address complaints. Overall, we found a combination of a lack of standard procedures for conducting investigations, which is a major point I would make you aware of. If they don't have a standard procedure to investigate complaints, then how are they going to do a good job investigating complaints? And workplace issues such as turnover and sick leave at the Office of the Ombudsman contributed to delays in processing investigations from 2009 to 2012. After 2012, the workplace environment stabilized and efforts to close long-standing files were successful. Procedures for investigations were being developed but were not still not incorporated into training for investigators. Not being able to perform an adequate investigation goes to the heart of why the Canadian Forces Ombudsman is failing. I wonder if I put that in there, because it looks like there's a notation the way I usually used to do footnotes in the past, but I don't recall doing it that way. D, paragraph 7.79. The workplace issues and lack of standard procedures contributed to delays in processing files. Overall, we found a combination of lack of standard procedures and it sounds like the same thing. I might have copied something in twice. Maybe that's what I was doing. Copy and paste went wrong. Anyway, you see my point. It's not just me saying that they're doing a crappy job. It's the people who are designed to look after the government integrity, accountability, called the Office of the Auditor General. Anyway, paragraph 2, the second thing I'd bring up after I lambasted them for, their failures. Number 2, I've been in contact with the Canadian Forces Ombudsman a lot. A, they refused a simple report or asked them to look into manually, and were they the insurer/underwriter of CISA Policy 901-102. With that in mind, why was I told yesterday that CISA is not a topic that they can investigate? I seem to be recalling told to contact the Office of the Veterans Ombudsman, but that can't be true, can it? After all, the reason I asked for a joint investigation into CISA is it forms the bulk of Veterans Affairs Canada's income replacement benefit. B. On one call before COVID, I had the unlucky experience of running into a new agent who listened for a while. That is, until I heard someone tell her to get off the phone, saying to me, the person I was talking to, after the other person told her to get off the phone, she said, "We have been told not to engage with you." Now, why would they not want to talk to Captain Retired Matt Edwards? Could it be they don't want to get my reports? Could it be they want to cover up things? Could it be they don't like someone questioning their stupid decisions and their stupid practices? Could it be? I think so. On that topic, I might try to find out where I posted about this. I am certain to have made a contemporaneous record here on social media, but I might also ask them for information on that subject in respect to the Privacy Act, as I have a right to that information. C. This point could have been placed in the first item, but I wanted to elaborate on it a bit. The Auditor General, Spring 2015, Investigation of Complaints. In 2011, an employee of the Office of the Ombudsman sent a complaint regarding the previous Ombudsman to National Defense. The complainant alleged that the office had a toxic work environment, that many employees and managers felt harassed, abused, and bullied, and finally, the office's mandate was not being carried out effectively. Now, that last point, I would say, is a judgment. The one about people being harassed, bullied, and abused, well, by who would be my first question. So then I put an editorial comment there. A toxic environment, work environment is bad. I don't need to say so, do I? How can someone do a good job when the entire workplace is toxic? Upon reflection, this may explain why I got nowhere in making my complaints, at least in part. D. Out of the picture here, where the Canadian Forces Ombudsman agreed that they would follow the Auditor General's recommendations. Yet, they still don't seem to understand how to investigate matters. For example, the report is the start of an investigation. With a report, how can they investigate something? I attached a picture from the Wujashina Supreme Court of Canada 1995 case, where criminal obstruction of justice pertained to interference with an investigation at the start of an investigation, when it is most vulnerable to a cover-up. Because if you want to cover up something, you stop the investigation in its tracks at the beginning, not after an investigation starts. So this is my key point here about why I'm not getting anywhere with anybody. Now 3, I put in the case Wujashina Supreme Court of Canada case post from 26th April 2018, because I've been researching this stuff for decades. Does the course of justice include investigations? Paragraph 27. The proceedings of a court, or indeed those of most administrative tribunals, will almost invariably commence with an investigation. Investigation is necessary to determine if a crime or wrong has been committed. It is an essential first step in any judicial or quasi-judicial proceeding which may result in prosecution. In the ordinary course of events, one who perverts the course of investigation also perverts the course of justice. For example, there is no question that someone who lies to a police investigating a car accident as to the identity of the driver is by that lie perverting the course of justice. Now, I hate to say this because I got qualms. That statement doesn't sit well with me, because if a witness, someone who lies is awful general, so if the police ask someone who did it, then they'd be asking someone to incriminate themselves. You're supposed to not have, the police are supposed to prove things beyond a reasonable doubt without you having to incriminate yourself. So, I don't know about this police statement there, right? They're trying to say that that's bad. They're obstructing justice. Well, do they have an obligation to reply? Do they have an obligation to tell the truth? What is their duty to answer the police? Anyway, my point about all this is that, see, these people these days, I think a lot of this stuff is people are just thinking that things are supposed to be a certain way. Like the lady yesterday was talking about the mandate of the Canadian Forces, Ombudsman. Now, I got so upset about all this crap, I looked it up a bit. And turns out that the Office of the Canadian Forces Ombudsman came into effect in 1998. Then they said that, yeah, that's what I believe too, Bob. So then they firmed it up with a thing called the Defense Administration Orders and Directives. If I remember the number right, or maybe I'll look at a picture, it's 5047-1. Now, you see, I've always had this question about things because I get obsessed with things. And the Queen's regulations and orders are subordinate law, regulatory law passed under the authority of the National Defense Act. But the military has been replacing the Queen's regulations and orders for a long time with what's called the Defense Orders Administration, DAOD, Orders and Directives. And I don't know if they're like the old regulations. I don't know if they're required to be followed, or if they're just a suggestion. So they talked about the Canadian Forces Ombudsman, and they defined the Ombudsman with a circular definition. They said the Ombudsman is the Ombudsman, which you're not supposed to do when you make a legal definition. So let me see if I include that. Okay, so when I'm looking through my pictures here, let me backtrack a bit and go over what they said for their response. So, paragraph 7.96, the Auditor General said, recommended, because I don't think the Auditor General can order people to do something. They're not like an Inspector General in the United States. They said in paragraph 7.96, the Office of the Ombudsman for the Department of National Defense and the Canadian Forces should finalize its formal investigation procedures and put in place training based on these procedures. Now, I was talking to several people today, the Enovets organization, asking them to get behind me on some of this stuff, and I was talking to a senior person at the Canadian Forces Ombudsman instead of a frontline worker. And the person at the senior management level, I said to them, it's pretty shameful that an organization came into existence in 1998, and in 2015, 17 years later, they are being told by the Office of the Auditor General that they should get formalized investigation procedures put in place, what the fuck were they doing all those other years? It goes to show what I've been saying, that these people don't seem to have a clue. Okay? So the Office of the Ombudsman's response said, agreed. As if they could say, no, go fuck yourself, we're going to continue being stupid, right? Standard operating procedures for the Office of the Ombudsman have been drafted and are being finalized among which are formal procedures for Ombudsman investigations. A request for proposal has been developed for a service provider. What the fuck are they talking about? See, I didn't read this before, I just posted the picture. A service provider to deliver the Ombudsman's Learning and Development Plan, probably because they don't have good enough people to deliver their own training, saying they don't have procedures, including training with respect to investigations and specific procedures developed for the Office of the Ombudsman. Now, goes back to what Bob was saying here, at least I think it is, I skimmed at what you said, but they don't want, the Department of National Defense and the Canadian Forces don't want complaints. So they don't want reports to be accepted by the Canadian Forces Ombudsman. They don't want investigators looking into things because, well, everybody just wants to keep doing what they're doing with nobody looking over their shoulder. You can't tell me I'm wrong. I think that's human nature, okay? So, now the next picture, seeing I'm kind of winging it here. See, one of the things that had me flabbergasted when I was talking to the Ombudsman person yesterday, I was trying to get them to start an investigation into the Service Income Support Insurance Plans, SISP. And she said, we don't have the authority to do so. And I said, well, how do you explain the 2003 Canadian Forces Ombudsman into the fucking Canadian Forces SISP program? If they didn't have the authority to do it then, they wouldn't have the authority to do it now, but they did have the authority then, so what the fuck happened in between? Which is why I don't trust them. Now, they did a piss poor job, by the way, in that Canadian Forces Ombudsman report. And this is one of the things that I was calling about, okay? So, the brainstorm I had that caused me to call them assholes yesterday was that I was looking at the reimbursement agreement. And I thought to myself, I'm going to post a poll. And I'm going to ask people to give me their authority to go to the Ombudsman and ask about somebody to look into the reimbursement agreement that Manulife and Maritime Life used to make people sign, but Manulife makes people sign now before you can get your long-term disability. Now, it seems to me that this is an easy way to attack what they do. Okay? Because, but what really galls me is that even if they don't have the authority to look into the system now, they ought to have, as I explained to a senior manager later, they ought to be able to go back and fix their mistake. Okay, so paragraph 72 of the 2003, I mean, it's 21 years ago now. So the background, the context is Disabled Pension Act veterans that were getting SISP put in a complaint to the Canadian Forces Ombudsman, about 50 people, and some of them people, besides saying that the clawback is wrong, some of the people complained about the fact that personal information had been transmitted from Veterans Affairs Canada to the Department of National Defense. Now, this seems to me to be a violation of the Privacy Act, first of all. But the question, the complaint, went to the Canadian Forces Ombudsman. According to SISP personnel, SISP does not collect, obtain personal information from VAC without the consent of the person to whom the information relates. When it is determined under the insurance policy that the insured is eligible to receive SISP long-term disability insurance benefits, the insured must sign a condition of benefits agreement before receiving any benefit payments. So there's an admission right there from the wrongdoer that they put duress on the insured person to get them to sign this condition of benefits agreement. Okay? So duress voids any consent. So someone puts a gun to your head and says, sign this or I'll kill you. You can sign it, but your consent don't mean squat. Now this is a financial gun that they put to your head, and they said if you don't sign it, you don't get paid. So right there and then, I don't understand why the Ombudsman ignored this fact. Okay? So this agreement contains the following provision. Paragraph 4, I further agree to notify the company in writing within 30 days of receipt of a benefit payment from other relevant sources. Now, editorial comment, timeout, I'll explain this paragraph. The person says, I agree. The company happens to be, at the time of this report, Maritime Life. Now, Maritime Life was the administrator of the policy from 1969 up until sometime in the early 2000s. Because Maritime Life belonged to John Hancock, I believe, and John Hancock, an American insurance company, got bought out by Manulife. I could look up the date if I cared. But because Manulife bought John Hancock, they acquired Maritime Life, and then they became responsible for administering the SISIP policy. Now, when they say other relevant sources, they're talking about other relevant income, because in the SISIP policy, Section 24A and Section 44A has the heading up above it that says other relevant income. Now, Canada Revenue Agency uses source of income as a method of taxation. So I think that's why the government said other relevant sources. But recall, it's not the government that said here that you had to pay us back. It's the company, which I will come back to later. So paragraph 5 is a very negative point, because it assumes that people will try to get away with something in the event that I fail to, or am unable to notify the company. As required by Clause 4, I authorize the Canada Pension Plan, Quebec Pension Plan, the Canadian Forces Superannuation Act, the Government Employee Compensation Act, Workers' Compensation Act, Automobile Insurance, and Veterans Affairs Canada to release to the policy owner and to the company. By the way, another interjection here. The policy owner is the Chief of Defense Staff on paper. And the company is supposed to be Maritime Life. Now, in theory, the contract of insurance is supposed to be between the Chief of Defense Staff as the policy owner or the policy holder or the insured, and the insurer, which would be Maritime Life, the company. But we know from the fact that the Chief of Defense Staff was ruled by the judge in the Manews case to be the actual underwriter, and that Manulife was described to be, if anything, a stranger to the policy, a third party that is not part of the policy, that is not part of the contract. They were not sued. So, I find it very disconcerting, suspicious that they put in here that, we have to release information, to the policyholder. I mean, it seems insane. Now, full details of any benefit made or payable to me and delivery of a photocopy of this agreement to those organizations shall be sufficient authority to release the information. Now, let me backtrack again. Consent has been a very sticky issue for me, because my Member of Parliament staff made it a very sticky issue for me, because I asked for their help in 2019 to try to get my SISIP long-term disability reinstated after they cut me off in 2017. And the first thing that set me off, triggered me, was the fact that they put in front of me a consent form under the Privacy Act, and they said, we want you to give us consent to talk to Manulife, to which I, having been fully versed all the research I did into the Privacy Act, know that there is no such consent required when you're trying to get a member of parliament to help you to solve a problem with the government under Section 8.2G of the Privacy Act. So that caused a lot of conflict with me and my member of parliament staff, because they kept saying things like to me to try to get me to sign it. Well, everybody does it. What's the big deal, Matt? Why are you not signing it? And the thing is I was saying to them, listen, boys, when Parliament made the Privacy Act back in 1982, if they hadn't put an exception for themselves in there in Section 8.2G, then I would be signing this consent form. But if they put the exception to the general requirement for a consent form, then they expect you to use it whenever possible. Tell me I'm wrong. Why would you put a consent exception in there and then proceed to require a consent form? It's, I hate to use the word because people might shit on me, retarded. It's insane. It's absurd. Okay? So all of this shit happened. I signed it anyway, just to get them out of my hair. I signed the fucking consent form. But I happen to know a lot about the law, even if I'm not a lawyer. And there's two different federal acts about privacy. One is called PIPEDA. Don't ask me what it means. But that is about private enterprises that are operating federally. Now, Manulife is, on paper, a private company operating on the federal level, and therefore they should have asked me for a consent under the PIPEDA Act, not the Privacy fucking Act. But those goddamn son of a bitches don't even understand that they're admitting that it's the government that insures Manulife by the fact that the Privacy Act is the consent form they want. I mean, why am I getting put through this ringer, this fucking bullshit that anybody with a brain should try to cover their tracks a bit better than what they are doing? And it's insane that they have been getting away with it for so fucking long. Now, getting off track a bit, I was going to go through a second post I made, but I think I'll just wing it because this consent reimbursement agreement, okay? The reimbursement agreement has the potential to stop them in their tracks. Okay, one of the main points I would make in the Manoj case settlement affidavit. Actually, no, it's in the case itself. My mistake. The government invokes, the Crown invokes the reimbursement agreement as justification about why it can take the Pension Act into account to reduce the liability of the Crown with its long-term disability insurance program. Now, the agreement itself doesn't mention the Crown. The agreement itself says the company. Now, there's a thing in the law, contract law, called privity of contract. Now, if they assert that this is like a contract, because it's not a contract, it's a condition of benefits agreement. But if they assert that this is a contract of sorts, then the named party is Manulife. And if Manulife wants to assert that right in a court of law, it can fucking try. But it wasn't a party to the Manoj case, so the government cannot assert a right that is owned on paper by Manulife. Boom, your head should explode. How did that slip past McKinnis Cooper? Do they know? Do they know about contract law? Do they know about the privity of contract? Do they know about freedom to contract? Because I've mentioned this 100 times before. Queen's Regulation and Orders 208.5 fucking 3 in 1982 required the deduction of premiums from a Canadian Forces member's pay. So the government passed a law to require that the premiums be paid into what looked like a private long-term disability insurance. Why are they giving such favor to a company that before you had a choice, you could say, no, I'm going to exercise my freedom of contract, and I'm just going to serve my country, and I'm not going to buy that insurance. You had that option up until 1982. But the government violated the law, the common law, about contracts in 1982, and they passed a law that required people to join it, the program. Now, when I've been looking at how to fix stuff with this thing, I don't know if we could just use that as evidence of wrongdoing, or should we ask for damages because they violated the common law on freedom of contract. So I'll take it under advisement either way. But now, the other thing that, well, that's kind of a minor point. I'll skip on to see what else I got here. Okay, I'm looking at a picture that shows what investigative process that the Canadian Forces Ombudsman did. It's in the report. So, paragraph 26, the Ombudsman investigators interviewed a number of witnesses, including the complainant, referred to above, and other complainants, staff working at D&D VAC, Centre for the Support of Injured Members, Mr. Pierre LeMay, the President of CISIP, and staff working for the Canadian Forces Director on the Quality of Life. Now, then they list off a whole bunch of stuff, like they received and reviewed a large amount of documentation, including case material provided by the complainant, referred to above, and other complaints about the Canadian Force, the Office of the Ombudsman, relevant Canadian Force administrative orders, relevant Queen's Regulation orders, hearing transcripts from the Croatia Board of Inquiry, 1999, blah, blah, fucking blah. Material on CISIP long-term disability benefits provided to members, CISIP and Treasury Board websites, the CISIP long-term disability policy, the Public Service Disability Insurance Policy, the Public Service Management Insurance Policy, and the RCMP long-term disability plan. Now, you see, the thing is, these are supposed to be benefits. But as I explained to the Anavets lady and the Canadian Forces Ombudsman senior staffer, long-term disability is supposed to provide a psychological benefit. Whitten versus Pollitt, Supreme Court of Canada, 2003. You buy the insurance never hoping to use it, but you're thinking that you have peace of mind that if something happens that you bought insurance for, then you will be covered. Now, you take the Manouche case. People paid their premiums, they bought the insurance. Then, when they became disabled, and they were disabled in service, because you had to get disabled in service to get the pension. Then the Department of National Defense Insurance took the pension into account and voided their peace of mind. Now, it might have been a partial voiding, by only part of the payment was clawed back, or it could have been a total voiding, VOID, if you don't hear me right. It's basically saying that they're getting rid of the policy as if it never existed because of clawbacks. Now that violates the principle of insurance, because you buy insurance to get the money if something happens. And for them to say, yeah, you would have gotten it, but you have enough money to look after yourself from these other payments. Well, I'm not going to get totally into it, but I did a post recently about CISIP being a private welfare program. It's even in the name. Service Income Support. See? That's one of the more recent terms that people use. Income support instead of welfare, instead of social assistance. They call welfare these days, a lot of times, income support. So there's a couple of things about it. If you have a private welfare program, well, you should report it on the proper tax slip, T5007. And you know something else? It's not taxable. So there is an argument to be made about the CISIP program, and it's not good or bad. I mean, is it or is it not factually, legally, a private welfare charity program. In effect, all insurance is, sort of. Because only some people are supposed to get it, the unlucky few. And all of the people that pay into it and don't have a misfortune, they are the ones who subsidize the ones who have the risk happen against them. So in effect, I mean, it might actually be a private welfare system. Now, there's also another argument to be made, that is the private workers' compensation type system. Because, evidently, private workers' comp systems are totally legit as long as it doesn't pay more than the government workers' compensation systems. So, the Toronto firefighters, for example, they have a private workers' compensation system. Now, the reason I know that is because I know of a case called Suchon, S-C-U-C-H-O-N, Supreme Court of Canada, or it could be the Federal Court of Appeal, 2003 case. And I got a lot of information about the way the system worked from that case. So in 1982, the government changed the way it worked on some things. And I believe they brought, like, welfare and workers' compensation payments were added onto your income for income-tested benefits and then taken promptly off for taxes. So in that way, they maintained a tax-free status, but they still got to save on income-tested programs, which are things the government pays that they decide not to pay if you have enough money to look after yourself. See? So this is what I keep telling people, like, in effect, clawbacks, hold on to your hats, is income testing, okay? So they don't say we're going to income test you to see if you have low enough money coming in to justify us subsidizing you. But what they do say is give us your financial details and then they claw it back. So they don't set a threshold like this is the amount that you have to make before they do it, which is worse really when you think about it, because Stats Canada has a thing called the Low Income Cutoff Line, LICO, which at one point was $42,000. So for a family of four, $42,000 was the amount that they said statistically you needed to survive. Now the government used that amount in the earnings loss benefit, which is now the income replacement benefit. I heard that back in 2015 or 2016 they were talking about LICO. And I was going nuts saying, do not bring in how much you need to survive. Because you're supposed to be paying someone compensation for their injury. You're supposed to be paying them damages equivalent, like the equivalent to a tort lawsuit. Now the next picture, I don't want to be here all night, and I hope I've made it a little bit interesting tonight with some of these anecdotes and facts and figures that I spit out off the top of my head. But one of the key things that I said to the lady in the Canadian Forces Ombudsman and the Anavets lady is that, listen, I think what's happening here is a turf war between the Veterans Affairs Department and the Department of National Defense. So, for example, I said, back in 2015, they brought in a new public policy to pay a disabled reservist the same thing as they will pay a disabled regular first person. Now, that is a good thing. Oh, I didn't have the picture there from the Canada Gazette. But when they did, I wasn't getting anything from back. But I was getting CISIP. So I called up CISIP and said, listen, boys, what are you going to do for me? Because I'm not in the Veterans Affairs system, but your contract says in Section 41A3 that I had to be hurt in service or I wouldn't get that long-term disability insurance. So what are you going to do? Are you going to increase the payment to the same thing as they're doing, which will be simpler because, you're paying me now. And so instead of them having to pay me in addition to you having to pay me, well, it would be simpler if you simply did the same thing as Veterans Affairs Canada. Oh, no. We're going to stick to the policy and you had to contact them, to get the top up. So I called Veterans Affairs like a good little boy. And they promptly said to me, you're not in our system. You are not getting any payments from Veterans Affairs Canada. So you have to contact SISIP, the Department of National Defense. So like I said to whoever I was talking to today, I felt like a tennis ball getting batted over the net. You know, one department didn't want me, the other department didn't want me, and I was getting slammed. I never ever got the right amount of SISIP because, well, why would they? They both avoided dealing with the problem. But you see, this is why I wanted a joint investigation into this shit in the first place, okay? How can they continue to play both ends against the middle and get away with it? Somebody other than Captain Retired Matt Edwards needs to hold their feet to the fire and get some answers. For example, there's a program arrangement in place between the Department of National Defense, Department of Veterans Affairs, and SISIP Financial Services. I would say it is negligence or gross negligence for them not to consider the condition of benefits agreement at the time that they were trying to talk about coordination of these rehabilitation programs. I would also say that it should have been incumbent upon them to think about the possibility of someone having something clawed back twice or 3 times. Because, you know, basically, each one wants to look after their own interests and they don't care about the other department. So in effect, what they've been doing is everybody has been applying the same thing. So the Canadian Forces pension might take the Canada pension plan into account and reduce your money. That's one clawback. Then SISIP claws back something. That's the second time he gets the Canada pension plan clawed back. Then Veterans Affairs Canada decides to claw back Canada pension plan for the 3rd fucking time. Now, I can't believe they've gotten away with this for 6 years, because in 2018, myself and Sean Kareem went over to the minister's office and we explained in no uncertain terms, I did all the talking, of course, but you can't take something into account 3 times. Okay? You can't give a person $1 of Canada pension plan and then take $1 off his Canadian Forces pension and then take $1 off his SISIP program and then you take $1 off his income replacement fucking benefits. You can't fucking do that and look in the mirror and say you're doing nothing wrong. You can't. Now, I'm going to do one more point, then I'm going to shut the fuck up. I thought of something about this goddamn reimbursement agreement that will, again, blow your fucking mind if you think about the implications of it. Before the Canadian Forces can take into account the Canada pension plan, before VAC can take into account the Canada pension plan, you made a contract, they would say, with Manulife, and you signed a condition of benefits agreement. Now, I happen to know a lot about the law. I keep saying that I sound like a broken record. The government has to respect contracts. Now, seeing that you signed this agreement and you said Manulife could take the money, then nobody else can assert a claim. The Canadian Forces pension can go fuck themselves because you signed that reimbursement agreement. Veterans Affairs Canada can take a flying fucking leap off of a bridge or a building, whatever that saying is that's escaping my mind. But you can point out that you signed a reimbursement agreement with a company named Manulife. And you know they can't ignore this contract of sorts that they tried to invoke. So you could invoke it against them, and they don't seem to be smart enough to realize that that voids any possible claim, because they got you to sign something to give it to Manulife, and then that means they relinquished their claim under other programs. I mean, one of these days someone's going to listen to me. I'm getting tired of this. I almost called this show off tonight. But I got a bit revitalized when I saw Trump get his just desserts. And I thought to myself, I'm going to make myself come down here, and hopefully what I do will help the other people who screwed over disabled veterans get their just desserts. Because I don't think, if you look at the Dennis Manogue class action, everybody, including the Ombudsman, seemed to look at this from a legal and a technical viewpoint. How about somebody look at this from a more human perspective? First of all, you had to be hurt on duty in order to get the pension. Secondly, you have to give up the right to sue in order to get a pension, because it's equivalent to workers' compensation. So now you have been A, injured on duty defending Canada. B, you gave up something of value to get that fucking payment. And then somebody has the fucking audacity to call it income when it's compensation for injury. Remember, the right to sue got exchanged for it. And then they called it income to justify their clawback. Then they didn't go to court, seek the court's permission, and then send a garnishment order to Veterans Affairs Canada after the court rules in your favor. No, you didn't do that. You simply said you signed a reimbursement agreement. You agreed that if you didn't have it already and you get approved later, you're going to pay us back. Now, in order to pay someone back, you have to have owed that person. Well, why did they owe? They only owe because they say you owe, and they say you owe without going to court and getting an independent judge to say that you owe. So you only have their word that you owe, which I would say the word is worth spit. Okay? There are so many mistakes that are happening. Again, I wish I could shut up. But the reimbursement agreement and the investigation in the SISIP, everything ties back to, is the government lying to us? If on the reimbursement agreement it says the company, which is Manulife, but the government has invoked it, so it's really saying the government should be there, then the piece of paper has false data on it. You're not allowed to lie to us. You're the government in a democracy. Okay? Under the Privacy Act, for example, accurate information must be accurate, right? You have to have the accurate information for the government to run its programs. But they have put a false name on the condition of benefits reimbursement agreement, and I can tie it to the Canada Pension Plan, disability. In order to get a direct payment, the Government of Canada requires that the person sign an irrevocable consent form that will allow the government to send your property to an insurance company. Now, this is against the law, the common law, because a pension payment has to go to the contributor, the person who established the pension, the person who put the money in the bank. You're not allowed to send money to somebody else because of trust law. There is a fiduciary duty owed to the contributor from the administrator, and for the government to use a legal means to send it to somebody else doesn't matter, because fiduciary duty is an equitable law principle, and you can't use legal arguments in an equity dispute. So clawbacks are also an equity issue. So if I owed you $2 and you owe me $1, then we just split the difference and exchange the $1 difference. That's an example of a clawback. So there has to be mutual debt between the two. Now, for the Pension Act pension, CISIP owed a legal debt to pay the insurance money, but they asserted a claim that the Pension Act reduced that amount, which created a debt. You see? So that's how they tried to justify it without actually stating it. That's how clawbacks work. But you see, on a technical and legal basis, the government thought of that, and they put Pension Act Section 30 into effect. And they said that the pension could not be touched in law or equity. So if you try to claw it back through legal means, a decent lawyer would say, listen, this pension is protected against interception in law, so go to hell. Now, if they went to a court of equity to try to say that, we have a right to this money because he owes us, and we're using equitable courts to collect the money, a decent lawyer would say to buddy, fuck right off, because the members of parliament that we elected, including you might not have voted for the person who put this law into place, but they ruled out equity as a means of intercepting this payment. You see how bad this is? Because the Pension Act pension clawback is wrong on so many levels. It's against the law, Pension Act Section 30. It's against the law, Financial Administration Act Section 67. It's against the common law because a non-indemnity payment was taken into account, an indemnity payment. So the payment meant to make you whole, the Pension Act, was being taken into account by a payment that is not meant to make you whole, but is simply an insurance policy that pays according to a formula. If anything is allowed to take anything into account, don't you think that the Pension Act should take CISIP into account? And taking that idea further, if Canada Pension Plan and private insurance are meant to interact, why do private insurances get to take the Canada Pension Plan into account when the government writes the law and they could put into the law, tell us if you're getting the private long-term disability insurance, and we're going to reduce your Canada Pension Plan disability accordingly. Tell me. They can't say that it can't happen because the reverse is true. So you have to wonder, how come the Canada Pension Plan is left holding the bag? This is nothing but a fraud, a scheme that they have set up to rip off disabled people, including disabled veterans. Listen, getting right out. Thanks for watching, and I'll see you next week.